There is a moment, and I want you to see this moment clearly because it matters. When a woman in a pale yellow blazer walked into my courtroom and sat down at the plaintiff's table, set her Hermes bag on the chair beside her like it had a ticket, and did not look once at the man she was suing. Not once. He was sitting 12 feet away from her. He had pulled her from a burning car 8 months earlier. He had burned the side of his hand doing it. He came to court that morning in a pressed shirt and a folder he carried under his arm. No attorney, no assistant, no paralegal, just a folder and a man who thought the truth would be enough. She did not look at him. I've been watching courtrooms for 39 years. I retired from the circuit court in Atlanta 14 months ago, and I can tell you this plainly. What happens when people think the room isn't watching? That is where the case actually lives. That is where the truth surfaces. Always. Without fail. In 39 years, I have never once seen a courtroom fail to eventually show you exactly who is in it. I'm Marcus Reed. 39 years on the bench. I've seen gratitude, and I've seen its opposite. This case was its opposite. And here is what I want to say before I go any further. This kind of case, where a person saves a life and gets sued for it, is happening more often than people know. I saw it. I'm naming it now while people are still willing to listen. Subscribe, because what you are about to hear is not a story. It is a record of what happened, and the record does not flinch. I'm going to tell you what happened in that room. Not to entertain you, because this is exactly how it works. The case was filed in Fulton County. Plaintiff, Diana Ashworth, 54 years old, socialite, philanthropist, former board member of 4 separate arts organizations. A woman whose name appeared in the society pages regularly enough that I recognized it before I read the complaint. Defendant, James Tanner, 41, long-haul truck driver, Duluth, Georgia. The complaint alleged negligence. The damages sought were $850,000, plus the replacement cost of a Valentino dress. I want you to sit with that for a moment before we go any further. Diana Ashworth's Mercedes AMG had gone into a guardrail on I-285 at approximately 7:40 in the evening on a Tuesday in March. A fuel line had ruptured on impact. The car was on fire, not smoking, on fire. James Tanner was driving his rig in the adjacent lane when he saw the smoke turn to flame and he pulled over. He was not a first responder. He had no training in vehicle extraction. He had no equipment. He saw a burning car and a woman trapped inside it, and he made a decision in under 8 seconds that most people who are being honest with themselves, would never make. He got out of the truck. He broke the passenger window of the Mercedes with a tire iron from his cab. He reached through burning glass, burning, not just hot, burning, and he pulled Diana Ashworth out of that car. 1 minute and 40 seconds later, the fuel tank ignited. The car was fully engulfed before the fire trucks arrived. Diana Ashworth's injuries from the rescue: a broken right wrist, a torn dress. James Tanner's injuries from the rescue: a second-degree burn on the outside of his left hand. 8 months later, Diana Ashworth's attorney filed suit. The complaint claimed that James Tanner had been negligent in the manner in which he extracted her from the vehicle, specifically that he had grabbed her arm with excessive and uncontrolled force, causing a spiral fracture of the right distal radius, and that she was entitled to compensatory damages for medical expenses, pain, suffering, emotional distress, loss of enjoyment of life, and the replacement cost of the dress, which her attorney informed the court was a Valentino couture piece valued at approximately $4,200. I read the complaint at my desk on a Monday evening. I put it down. I picked it up again. I read it a second time because I wanted to be certain I had read what I thought I had read. I had. The morning of trial, I watched Diana Ashworth enter my courtroom. She wore the pale yellow blazer. Her attorney, a man named Gerald Fitzpatrick, polished, bespoke, the kind of attorney whose suits cost more than some of the settlements I had approved in 39 years, walked beside her with the posture of a man who had won this argument before. Her posture was different. She moved through the room like she had reserved it in advance. She sat. She arranged her bag on the chair beside her. She arranged herself. She did not look at James Tanner. James Tanner was already seated. He had come early. He was always going to come early. That was already clear from looking at him. The folder was on the table in front of him, organized. I could see this from the bench, with tabbed dividers. He had spent real time on that folder. He looked up when she entered the room. She did not look back. She looked at Fitzpatrick. She looked at the table. She looked at the window. She did not look at the man she was suing. I've seen this before. Not this exact case, this dynamic. The one where someone who has been sued for something decent sits very still and waits, because they believe the room will eventually see what is obvious. And the one who filed the suit moves with the confidence of someone who has decided the room is a tool rather than a witness. The room is always a witness. That is what I know after 39 years. Fitzpatrick's opening statement was polished, and it was constructed with skill, and it was, in the most important sense, wrong. Not factually wrong in its individual claims. Every word in it was technically accurate. He described the accident with precision. He described Diana's injuries with documentation. He described the manner in which James had pulled her from the vehicle, and here is where the craft was on display, as an extraction performed with significant and uncontrolled force, without regard for the physical welfare of the plaintiff, producing a spiral fracture of the distal radius consistent with torsional stress applied to the forearm. He used the words reckless and negligent and foreseeable harm in the same sentence. He made it sound like James Tanner had done something careless, something that a more careful, more trained individual would not have done. He described James as someone who had acted with the best intentions, but without the competence or care required to avoid causing injury. Best intentions. Without competence or care. I wrote those words down. I write things down when they matter to me. Those words mattered, and I knew I would come back to them. James Tanner had no attorney. He had approached two. One had quoted him a retainer he couldn't afford. One had told him the case was too complicated for a quick consultation. He had his folder. When Fitzpatrick sat down, I asked James if he wanted to make an opening statement. He stood up. He said, "Your Honor, I just want to say what happened." I told him to go ahead. He described the accident the way a person describes something they actually witnessed and cannot forget. Not performed, present. He said he was in the left lane doing 60 when he saw the smoke coming off the Mercedes. He said he pulled over immediately, put his hazards on, came around the front of his rig to see the situation. He said the fire was coming from underneath the vehicle on the driver's side, moving fast. He said he heard her, Diana Ashworth, inside the car. He could hear her voice. He said she was conscious. He said the driver's side door was crumpled against the guardrail, couldn't open it. He went to the passenger side. The door was locked and buckled from the impact. He said he got the tire iron from behind his seat. He kept it there. He'd kept it there for 15 years, and he broke the passenger window. He said she was still buckled in, seatbelt. He said the smoke was coming up through the floor of the car, through the carpet, and it was the kind of smoke that means fire is close to the interior, not distant. He said, "I put my hand through the window and I grabbed her arm because that was what I could reach. The door was crushed on her side and her legs weren't moving right. I didn't know if she was pinned or not. I couldn't see clearly. I pulled. I pulled as hard as I needed to. The fire was coming through the floor." He said it plainly. There was no performance in it at all. He had rehearsed nothing. He said he had pulled her across the center console, through the window gap, across the broken glass onto the shoulder of the road. He said he did not know her wrist was broken until later, until an EMT told him, when the EMTs were already there and he was sitting on the guardrail with his hand in the cold. He said that when the tank blew, he and Diana were both lying on the ground 20 feet from the car, and the heat from the explosion was enough to feel on his face. He sat back down. Then came the medical evidence. Fitzpatrick's medical expert was a Dr. Weston Hargrove, orthopedic specialist, board certified, who billed at $300 an hour for consulting work. He testified that the spiral fracture pattern in Diana's right wrist was, in his expert opinion, consistent with rotational force applied to the distal forearm, specifically a torsional stress that would result from grabbing the arm and pulling while the wrist was in a fixed or braced position against the door interior. He testified that a trained rescuer, following established vehicle extraction protocols, would have supported both the elbow and the wrist during the extraction to minimize torsional stress on the joint. I let Hargrove finish. I let Fitzpatrick finish his examination. Then I asked Hargrove a question, one question. I asked him, "What is the expected extraction time from a vehicle with an active fuel line rupture and interior fire before ignition of the fuel tank?" Hargrove said the answer depended on specific circumstances. I told him, "Assume the circumstances described in this case. A ruptured fuel line, fire entering the interior, access limited to a passenger window, occupant belted in, door obstructed. He said, in those circumstances, a rescuer would have a limited window. He said the window would vary. I asked him, in your professional experience and training, would the standard vehicle extraction protocols you described, the ones requiring support of the elbow and wrist, be designed for emergency extraction from a burning vehicle or for standard medical extraction under controlled conditions? He paused. He said the protocols were developed primarily for controlled extraction scenarios. I asked, and a spiral fracture of the distal radius, is that injury survivable? He said, yes, of course. I said, and a fuel tank ignition at close range? He said nothing for a moment. He understood what I was asking. Then James produced his own document from the folder. Not a medical expert, he couldn't afford one. He had found and printed a peer-reviewed study from the Journal of Emergency Medical Services, which he had located at the Duluth Public Library. He had found it himself on his own time because he wanted to understand what had happened to her arm. The study examined the biomechanics of emergency vehicle extraction under fire and smoke conditions. It found that in fires involving fuel line rupture, the median extraction window before ignition was between 90 seconds and 4 minutes. It found that trained first responders routinely applied torsional force to limbs during emergency extractions when lateral movement was obstructed by damage to the vehicle frame. It found that the incidence of fracture in emergency extractions under fire conditions was consistent across both trained and untrained rescuers, because the circumstances, not the training, dictated the required force. He had highlighted the relevant passages in yellow. He had tabbed them. He had written the exhibit number on a sticky note on the front. The witness was next. A man named Calvin Pruitt, 37, from Kennesaw, who had been driving northbound on I-285 that evening and had filmed 30 seconds of the rescue on his phone before pulling over to help. He had given the footage to police the night of the accident, filed as part of the incident report. James had subpoenaed it through the police department's records office and entered it as Defendant's Exhibit 1. I watched it in court. Fitzpatrick had watched it before. I could tell. He had prepared for it. But the gallery had not seen it, and I watched them watch it. The footage was 32 seconds long, shot through a moving windshield, so the first 8 seconds were blur and angle changes as Pruitt was pulling over. Then it steadied. You could see James at the Mercedes on the left side of the frame. The smoke was significant. Not a small column, a full billow coming from beneath the vehicle, rolling across the shoulder. You could see him at the passenger window. The window was already broken when the camera steadied. You could see him reach in. You could see him pull. The angle didn't show Diana's face or position clearly, but it showed James's. And what was on his face was not recklessness. It was not carelessness. It was effort, pure, physical, all-in effort against something that was not cooperating. He wasn't yanking, he was working. He was working against a buckled door frame, a seatbelt that may or may not have released cleanly. A woman who was in shock and whose body was not responding the way an alert, cooperative person's body would respond to being pulled through a broken window. At the 18-second mark in the footage, you could see the first tongue of flame come up through the floor panel on the driver's side, orange against the gray smoke. At 23 seconds, James had her out. The footage ended. Fitzpatrick objected to its introduction on the grounds that it was prejudicial. I overruled him. Evidence that directly depicts the events in question is relevant. Evidence that is relevant is admissible. He knew that. He objected anyway because that is what you do at the defense table when the footage isn't helping you. You object, you create a record, and you hope. He had no hope with this footage. He knew that too. Now I want to tell you about the deposition. Because this, not the footage, not the medical testimony, not the library research in the folder, this is where the case turned. This is the moment the room showed me exactly who Diana Ashworth was, in her own words, on her own record. She had been deposed 4 months before trial. James had represented himself at the deposition too, sitting across from a court reporter and Fitzpatrick's associate with his folder and his questions that he had written by hand on a legal pad. He had asked her about the accident, about her recollection of the rescue, about her injuries, about the treatment she had received. And then he had asked her, and I read this in the transcript, this is not paraphrase, this is the verbatim record of a deposition taken under oath. He had asked, "Ms. Ashworth, at any point after the accident, before you filed this lawsuit, did you contact me to say thank you?" And she had answered, "That's not relevant to my damages." That sentence. I had read it 4 months before trial. I had read it the morning of trial. I had it written in my notes. I want to tell you why that sentence matters, and I want to be precise, because precision here is everything. There is no legal requirement to express gratitude before filing a lawsuit. None. Gratitude is not a tort defense. If James had been genuinely negligent, if he had, in fact, carelessly injured Diana Ashworth when a more careful person would not have, her failure to say thank you would not change that. The law does not trade in gratitude. But what the sentence revealed was not a legal issue. It was a window. It showed me the architecture of how Diana Ashworth had framed this situation in her own mind. She had not called James Tanner and then decided the wrist injury was still worth litigating. She had not drafted a thank you note and set it aside while the lawyers worked. She had not wrestled with the question at any point, in any form. The question, should I thank him before I sue him, had simply not arisen for her. Because she had placed the accident, the rescue, and the lawsuit in separate categories that had no relationship to each other. The rules of gratitude, in her framework, genuinely did not apply to her situation. Not because she was lying, not because she was hiding something, because she actually believed it. That's not relevant to my damages means. It is a complete sentence. It is a complete worldview. I ruled from the bench on a Friday afternoon in October. The gallery had filled in the days before. Word about the case had moved through Atlanta the way certain cases do, the ones that touch something people recognize. I looked at both tables. James Tanner had his hands folded on top of the folder. Diana Ashworth was looking at a point somewhere to the left of Fitzpatrick's shoulder. I said, "In the matter of Ashworth v. Tanner, this court finds in favor of the defendant." I said, "The evidence before this court establishes that on the evening of March 14th, James Tanner observed a vehicle fire on Interstate 285, stopped his vehicle at personal risk to himself, and extracted the plaintiff from a burning automobile in a manner that, given the conditions present at the time of the extraction, specifically an active fuel line fire, an obstructed driver's side door, a belted occupant, and an ignition that followed the extraction by approximately 77 seconds, was not negligent. The force applied was the force the circumstances required. The injury sustained by the plaintiff, while real and documented and genuinely painful, was the cost of a survival that would not otherwise have been possible." I looked up from my notes. I said, "This court further notes that the extraction performed by Mr. Tanner in approximately 23 seconds, under conditions that produced a full fuel tank ignition in less than 90 seconds, was not merely reasonable under the emergency circumstances doctrine. It was the reason Diana Ashworth is alive to appear in this courtroom today." I paused. I let that stand in the room. I said, "Plaintiff's claims are dismissed with prejudice. Court costs are assessed against the plaintiff. The question of attorney's fees for the defendant's out-of-pocket costs in defending this action, given that the defendant was required to represent himself against a suit this court finds to have been without legal merit from the outset, is remanded to post-judgment proceedings for consideration." I heard the gallery before I finished the final sentence. It wasn't applause. I do not permit applause in my courtroom, and everyone in that room knew it. It was something else. The sound of breath releasing all at once, from 40 people simultaneously. A sound you feel in your chest more than you hear with your ears. It passed through the room in about 2 seconds, and then there was silence again. Diana Ashworth did not react visibly. Gerald Fitzpatrick was already writing something on his legal pad. I noted that he had stopped writing before I finished speaking. He had written what he needed to write, and he was waiting. James Tanner looked at the table for a moment. Then he looked up at the ceiling. Then he looked at his folder. Then he looked at me briefly, and I gave him the small nod that is the only communication a judge can give in that moment, which means, I saw it. The room saw it. I walked back to chambers. I have thought many times about why that case stays with me the way it does. I have had larger cases. I have had harder cases. I have issued rulings in 39 years that changed more, touched more people, mattered in ways that Ashworth v. Tanner never will to anyone outside of Atlanta's Fulton County. But this one stays. It stays because of that sentence in the deposition. That's not relevant to my damages. Not a lie, a worldview. Diana Ashworth had genuinely organized her universe into a framework where the man who pulled her from a burning car was a variable in a damages calculation, and his burned hand and his library research and his folder with yellow highlighted tabs were things that existed in a different category than her Valentino dress and her broken wrist. She was not pretending. That was the actual map she was reading from, and that is something I had not seen in quite that form in 39 years. Not the entitlement. I had seen entitlement in every variation possible. What I had not seen, stated that plainly, that cleanly, without any apparent awareness of what it was revealing, was the complete absence of the question itself. The man who saved her life was not a person the question touched. 39 years watching what people do when they think the room isn't watching back. It always is. She thought the room wasn't watching. She thought her attorney's polish and her Hermes bag and her expert at $300 an hour had arranged the room into something she could control. The room was watching. It always is. It watched the folder. It watched the library study with the yellow highlights. It watched 32 seconds of footage shot through a windshield on a highway shoulder. It watched her not look at him. There are cases you carry because they were complicated. And there are cases you carry because they were simple, so clear, that the simplicity itself becomes the indictment. This was the second kind. A man pulled a woman from a burning car. She sued him for it. He had a folder and a library card and the truth. He went home. I hung my robe for the last time 14 months after that ruling. On my way out, I thought about a small number of cases, not the biggest, not the most famous, but the ones that showed me most clearly what the work was for. Ashworth v. Tanner was in that group, not because it was exceptional, because it should never have been necessary, and because James Tanner, who had no training, no resources, no attorney, and a folder he'd organized himself, walked into a room that was watching, and the room saw him clearly. That is what justice looks like when it works. Not dramatic, not theatrical, clear. If you've ever been in a room where that happened, where the truth was enough, where the right thing was done because someone did the work and told the truth and the room saw it, I want to hear about it. Leave it in the comments. I read every one. Share this, not for the entertainment value, though I understand why the title drew you in. Share it because someone you know may be standing right now at the edge of exactly this situation, doing the right thing and finding out that it has a cost they didn't expect. They need to know the room is watching. It has always been watching, and it always will.